Idaho has one of the most landlord-friendly breaking lease frameworks in the country, with minimal state-level regulation and strong preemption provisions that prevent local governments from adding requirements. The governing law is found in Idaho's landlord-tenant statutes, Idaho Code Title VI, Chapter 3, along with general contract principles. If you're a landlord or tenant in Idaho, the state gives landlords broad discretion while recognizing the basic duty to mitigate. Let's start with the landlord's duty to mitigate damages. Idaho law recognizes the landlord's duty to mitigate when a tenant breaks a lease and vacates. This duty is established through Idaho case law and general contract principles. The landlord cannot leave the unit vacant and hold the departing tenant liable for the full remaining rent without making reasonable efforts to re-rent. The landlord must take reasonable steps, advertising, showing the property, and accepting a qualified applicant. The departing tenant's liability is limited to rent during the vacancy period, plus reasonable re-rental costs. If the landlord fails to make reasonable efforts, the departing tenant's liability is reduced. Idaho's preemption statute, Section 55-307, limits local governments from regulating certain aspects of the landlord-tenant relationship. This preemption ensures statewide uniformity. No Idaho municipality has enacted local provisions that add breaking lease requirements beyond state law. Boise, Meridian, Nampa, Idaho Falls, and every other Idaho community operate under the same framework. Early termination clauses are generally enforceable in Idaho. The state does not cap early termination fees. A clause requiring 30 to 60 days notice and a fee of 1 to 2 months' rent is typical and enforceable. Idaho courts enforce reasonable contractual provisions and give significant deference to negotiated lease terms. A grossly excessive fee could be challenged as an unenforceable penalty, but Idaho's legal culture favors freedom of contract. Military members have the right to break a lease under the SCRA. Mountain Home Air Force Base near Mountain Home generates military rental demand in both the Mountain Home area and the broader Boise metro. Active duty service members with qualifying orders can terminate by providing written notice and a copy of the orders. The lease terminates 30 days after the next rent due date. No early termination fee or penalty applies. Idaho does not have a specific state statute providing enhanced lease-breaking protections for victims of domestic violence. Idaho does have the Domestic Violence Crime Prevention Act, which provides protective orders, but the act does not include a specific lease termination provision. Domestic violence victims who need to break a lease must rely on general contract principles, negotiate with the landlord, or seek assistance through advocacy organizations like the Idaho Coalition Against Sexual and Domestic Violence. This gap is notable given Idaho's rapidly growing and diversifying population. Including a voluntary domestic violence termination clause in your lease is a recommended best practice. Tenants in Idaho may break a lease if the landlord fails to maintain habitable conditions. Idaho recognizes an implied warranty of habitability in residential leases. Under Idaho Code Section 6-320, the landlord has obligations regarding the condition of the premises, including maintaining the structural integrity, plumbing, heating, and electrical systems. If the landlord fails to address serious deficiencies after receiving proper written notice, the tenant may have grounds for lease termination. The tenant must provide written notice identifying the specific deficiency and allow a reasonable time for the landlord to make repairs. Typically 3 days for conditions that are imminently dangerous to health or safety, and a longer reasonable period for less urgent issues. If the landlord fails to act, the tenant may terminate. Idaho also recognizes constructive eviction. If the landlord's failure to maintain the property or affirmative actions, shutting off utilities, failing to address dangerous conditions, changing locks, render the unit uninhabitable, the tenant can treat the lease as terminated. The tenant must vacate within a reasonable time. Idaho has specific provisions regarding abandonment. Under Idaho Code Section 6-303C, if a tenant abandons the property, the landlord can retake possession. The landlord should document evidence of abandonment before entering: unpaid rent, absence from the property, removal of belongings, failure to respond to contact attempts. The departing tenant remains liable for damages subject to the mitigation duty. Idaho also has provisions regarding the tenant's personal property left after abandonment. The landlord must follow proper notice procedures before disposing of abandoned property, giving the tenant an opportunity to retrieve their belongings. From a practical standpoint, Idaho has been one of the fastest-growing states in the country, and the strong rental market generally benefits tenants who break leases because landlords can re-rent quickly. Boise is Idaho's dominant rental market. The Boise Metro, including Meridian, Nampa, Caldwell, Eagle, and Star, has attracted enormous in-migration from California, Oregon, Washington, and other higher-cost states. When a tenant breaks a lease in the Boise Metro, the landlord can typically re-rent within 2 to 4 weeks, and often faster in desirable locations. The departing tenant's financial exposure is usually limited. Meridian has been one of the fastest-growing cities in the entire country. Nampa and Caldwell have more affordable markets that have attracted residents priced out of Boise. Re-rental across the Treasure Valley is generally quick. Boise's applicant pool increasingly includes out-of-state relocators, many from California, Oregon, and Washington, where they were accustomed to much more tenant-protective breaking lease frameworks. These tenants may expect protections that don't exist in Idaho, such as statutory caps on early termination fees or specific domestic violence termination rights. Idaho Falls has a moderate market driven by the Idaho National Laboratory. Re-rental is moderate. Pocatello, home to Idaho State University, has a student-influenced market. Twin Falls has a moderate market driven by agriculture and food processing. Coeur d'Alene and the Northern Panhandle have experienced significant growth driven by remote workers, retirees, and quality-of-life migrants. The market has tightened substantially, and re-rental is generally quick. Moscow, home to the University of Idaho, has a student market. Rexburg, home to BYU Idaho, has a unique student market shaped by the university's cultural dynamics. Sun Valley Ketchum has an extremely expensive resort market where workforce housing lease breaks can be filled immediately given the desperate demand. One best practice for Idaho landlords: include a clear early termination clause in your lease. Idaho's preemption ensures statewide uniformity, so you can use the same clause across all your Idaho properties. Specify the notice period, fee, and process. Given Idaho's strong market where re-rental is typically quick, calibrate the fee to your realistic expected vacancy. A 2-month fee may be difficult to justify when you can re-rent in 2 weeks. Another best practice: begin re-rental efforts immediately and document every step. Idaho's strong markets mean you can minimize vacancy, but only if you act quickly. Keep records of listing dates, advertising platforms, inquiry counts, showings, and acceptance dates. A third best practice: consider voluntarily including a domestic violence termination clause in your lease, even though Idaho doesn't require it. A clause allowing termination with 30 days' notice and a copy of a protection order costs you nothing in normal circumstances and protects vulnerable tenants when the need arises. It also reduces the risk of a tenant fleeing without notice, creating a worse outcome for both parties. Idaho requires landlords to return the security deposit within 21 days of the tenant vacating, or up to 30 days if the lease specifies the longer period. There is no statutory cap on the deposit amount. The landlord must provide an itemized statement of any deductions. These rules apply to broken leases and normal move-outs alike. For the complete guide to Idaho breaking lease laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our Breaking Lease Law series.